Peter Millward, Acting Deputy Director General, Translink Division, TMR.
And John Robluski, Acting General Manager, Transport Regulation Branch, TMR.
Thanks, John. You got an opening statement?
Yes, I do.
Thank you.
Thank you. Firstly, thank you for giving myself and my other Department of Transport and Main Roads colleague the opportunity to speak to you today about the Taxi Legislation Amendment Bill. Before taking your questions and discussing the Department's view on the amendments, I would like to make a short opening statement which I hope will provide some context to how the Department has come to its view. By way of background, the Transport Operations Passenger Transport Act 1994 and its subordinate legislation regulates vehicles licensed as taxis, people authorised to drive taxis and operators accredited to provide taxi services. The intent of the Act is to provide the travelling public with a level of confidence in the taxi industry, safe in the knowledge that service providers and their vehicles are appropriately assessed, regulated and monitored. In addition to this, the Act is also designed to promote passenger safety, driver safety, public convenience and accessibility. Examples of some of the visible benefits this regulation provides include the requirement for taxis to have security camera systems fitted, which provides peace of mind when customers enter a taxi service. The taxi subsidy scheme, which is designed to assist with improving the mobility and quality of life of residents with a disability. The minimum service levels applied to taxi booking services to ensure customers can get home and get home safely. And the extensive vehicle requirements which certify that vehicles are subject to ongoing inspections and age limit requirements which ensure that vehicles are safe. That being said, the passenger transport legislation was written some 20 years ago and did not foresee the emergence of software apps which facilitate unauthorised taxi services. As a result, for a range of reasons, services provided by entities such as Lyft and Uber, as well as other emerging smart phone platforms, are not contemplated or authorised by the legislation. Although these reasons vary depending on the entity, the main issues of contention include they provide a taxi service without a taxi service licence, and drivers of these services operate without the appropriate driver authorisation. I acknowledge that because of this, the wider taxi industry is frustrated and that these types of unauthorised passenger transport services are currently operating contrary to the Act. In response, the Department is well aware of these frustrations and we are taking a number of actions to address these concerns. Before briefly outlining these actions though, I would like to highlight that the Deputy Premier has recently announced an independent task force to review personalised transport services across Queensland. The review will investigate opportunities to uphold safety standards, meet customer needs and increase competition. The review must also identify what a potential future market state could look like. This may include, but is not limited to, an appropriate long-term flexible regulatory framework focused on service outcomes, where costs do not exceed the public benefits, which is also innovative and accommodates future progression. Addressing the needs of the community across Queensland, including those with disabilities or reduced mobility. The safety of the community and drivers, and appropriate compliance strategies and enforcement measures which can adapt in line with industry progression. To achieve this, the task force will be supported by a review secretariat who will report to the chair of the task force. As per the task force's terms of reference, the task force will be responsible for engaging and consulting with stakeholders and the wider community to ensure views are appropriately considered. Additionally, the task force is required to develop a shared set of guiding principles to shape the reform options and recommendations for government consideration, develop a consultation paper to support public discussion on reform options, report on progress to the Deputy Premier, and develop a final report that presents recommendations and reform options and details the preferred option for Queensland Government consideration. The task force is strictly independent of the department, and you're here to understand what the department's view is on the taxi legislation amendment bill. Therefore, to elaborate further on this, I would like to hand over to John Wroblewski from the department's Customer Services Safety and Regulation branch, and then following this we are happy to take some further questions.
Thank you.
Thanks, Peter. TMR is continually evaluating enforcement techniques for effectiveness and is investigating new methods and enforcement strategies. Department compliance officers have dedicated over 14,700 hours to the interception of vehicles and the collation of evidence associated with illegal taxi services. These compliance activities are essential for two key reasons. Firstly, they are crucial in ensuring that the provisions of the Act are adhered to. Those who choose not to adhere to the Act are dealt with via the enforcement mechanisms available to the Department through the Act. Secondly, by having boots on the ground and officers visible on the street carrying out these activities, compliance officers act as a deterrent to companies who operate unauthorised passenger transport services, as well as their drivers. The visual presence of these officers ensures that all parties are aware that the services they are providing are not authorised and, by extension, discouraged from providing those services. That being said, there has been increased challenges in identifying Uber drivers, noting the avoidance strategies by Uber and its drivers already on record. Transport inspectors also need to have sufficient evidence to ensure that a penalty infringement notice in any particular circumstances can be issued. In response, the Department is reviewing its compliance strategy within the constraints of the current passenger transport legislation. Understandably, the Department is reluctant to share specifics of those ongoing operational compliance strategies. In general, though, compliance activity has been ongoing and further compliance activity is planned over the next few months. A range of options have also been considered with regard to better supporting transport inspectors during their on-road compliance effort, as well as options to enhance the existing legislation and to ensure it's contemporary while maintaining the intent of the law that was originally drafted. It is important to note that within the context of the taxi review, which is looking at an appropriate long-term regulatory framework and compliance strategies. With respect to the content of the bill we are speaking on, the Department believes further consideration needs to be given to the bill in its current form. There are two main reasons for this. While demerit points are typically linked to offences with a road safety risk like speeding, mobile phone use or failing to stop at red traffic lights, the Committee needs to consider the use of demerit points in the context of intent and operation of the legislation. This is to ensure that appropriate safety behaviours are achieved and drivers comply with driver authorisation requirements. The Committee would also need to consider whether the allocation of demerit points to an offence with a primary regulatory or economic outcome is appropriate. Double demerit points are only currently applied to very high-risk driving behaviours where other harder sanctions are not available. Double demerit points currently apply to failure to wear an approved motorcycle helmet, speeding in excess of 20 km per hour of the posted speed limit, fail to wear a seatbelt and using any function of a mobile phone that is held in the driver's hand. Applying double demerit points for an offence without a clear road safety link would be a significant shift. The bill also does not adequately address the issues experienced in the compliance and enforcement of unauthorised services. The allocation of demerit points in isolation of other supporting measures will not be enough to adequately deal with avoidance strategies such as those that you have been using and the application of current legislation, including corresponding offences, which was written some 20 years ago. Any consideration about the allocation of demerit points would be enhanced by also considering these key factors. We're happy to take any further questions.
Thank you. A member of the public jumps into a vehicle, is moved from point to point A to point B. Can you tell me when does that the movement of a vehicle and carrying a passenger become a taxi service? What makes it a taxi service? What's the meaning of taxi service?
There's a piece of work that we've done which explains the legislation, how it's implied, the elements we'd have to prove to determine whether a person was providing a taxi service and then whether they had the correct authority. There are lots of elements to the proof of that. I can't provide that with you at the moment because it's just too complicated for me to repeat, but I'm happy to make it available to the Committee.
Thank you very much. Have you applied any of those to the current situation?
The team are using that layout to work through the current pending charges.
Okay. Michael?
1,536 pins have been issued since July 2014. How many in the last month?
I don't have the figure for the last month. Sorry, again, I'm happy to make that available.
Is it 0 or above 0?
I'm sorry, I don't actually have the number, sorry.
Okay.
We'd have to take that on notice.
Can you take that on notice again?
Certainly.
Yes.
Now, I understand that you don't want to talk publicly about what sort of action you may be taking.
Yes.
But are you happy to talk to the committee privately about those issues?
Yes.
Okay.
I think the other consideration there, through the chair, is that through the review processes there will be consideration around some of the regulatory options. So
Sure.
that'll be a fulsome consideration.
Are you
of that
aware?
process.
Are you aware of the amendments that the Taxi Council has put forward with regard to giving police powers to pull over people that are deemed to be breaking the law, or making sure that those laws are referenced in the Police Powers Act?
I haven't specifically seen that reference. We have talked about the existing powers capable to compliance inspectors inside our own work. Again, I'd rather not talk about available powers because it relates to strategies and tactics and how we undertake work in a public hearing.
Yeah, that's good. Thanks.
Right.
Just you mentioned there before, and I believe this is what you were saying, that Uber provide a taxi service without a taxi licence. Is that correct?
They're currently deemed as, under the Act, they're an unauthorised service. Our focus is on passenger safety. Our view is that people should be using those services that are authorised by the legislation, such as taxis, for those primary safety considerations.
Okay. So basically you consider it as they provide a taxi service without a taxi licence. Under the Act, does the department interpret this as breaking the law?
We believe the service is unlawful.
Yep.
We believe it's an unauthorised service.
Okay, thanks. You good. Brittany, last question.
Has a complaint been made at all on behalf of the government to Apple if the app is in breach of if you say it's unlawful in the state of Queensland and the Apple guidelines require that apps must obey by the law in which in the state in which they're offered?
I think we'd have to take that on notice because there's implications around the Telecommunications Act too and some of the ramifications that we might need to consider there. So if I could, I'd take that on notice. Thanks.
All right. I've just had it pointed out to me that there is one question which we feel as though we must ask as part of this today's hearing. Can you please give us some information about the cease and desist order provided to Uber in May 2014? What is the process following a failure to comply with a cease and desist order?
I don't have any further information on the cease and desist order. We'd have to take that on notice and provide that back to you.
Okay.
But I think there's been a level of compliance activity which we've referred to in terms of the number of hours that have been put into compliance activity.
Okay, thanks very much. Could we have those documents you promised us by the 7th?
7th December, yes.
Yep. Thank you. Thank you very much.
Okay, thank you.
Righto, Robbie.